Good morning. Well, my name is Moses Cairo, and I have the honor or privilege of serving as the Dean for the School of Agricultural and Natural Sciences at the University of Maryland Eastern Shore. I'm delighted to welcome you all to this 10th Annual Agricultural and Environmental Law Conference. I think it's truly remarkable that this is the 10th installment of this annual conference. We are very pleased to be able to gather here with all of you being stakeholders in agriculture. This conference itself has proven to be quite unique because it brings together a broad range of stakeholders to really engage in a purposeful dialogue about supporting profitable and sustainable farming in a time when regulations are constantly changing and key stakeholders need to continuously adapt to all these changes. The agricultural law education itself has truly matured. I recall that during its infancy, nearly 12 years ago, a critical guiding principle was to listen and be guided by stakeholders and their needs. This conference, in a sense, continues that ethos because on the one hand, in addition to sharing knowledge, the other part is also to get feedback from you in terms of what your needs are and what challenges that you're facing. So this year's conference brings together another very full and purposeful agenda. We are happy to have speakers from Maryland, Baltimore, University of Maryland, Baltimore, Francis King Curry School of Law, West Virginia University School of Law, the Ohio State University, the Maryland Food Bank, Fast Fruit Farm, as well as county and state agency leaders and leaders in law and advocacy, and of course our Maryland Extension team. This broad team of speakers will share with us their unique perspectives and insight into topics from developments in right to farm laws, food donation laws, and the future of regulating value-added agriculture to Maryland's new regulations for using food processing residuals, and of course developments in solar energy in Maryland. As always, we really do urge you to engage with the speakers and get the most out of the different panels. Please ask as many questions as you can. Clearly, as Marylanders, we need to work together to keep Maryland being a leader in agricultural production and agricultural enterprises, and really providing leadership in a number of areas, including this particular area that we are discussing at this conference. For us at the University of Maryland Eastern Shore School of Agricultural and Natural Sciences and UMES Extension, we remain very focused on the idea of working with your stakeholders, with our students, developing the workforce of tomorrow, and providing enhanced knowledge and technology to improve the viability of agriculture in the broad context. We are really committed to serving all the communities and citizens of Maryland in this regard. But I'm delighted that over the last decade, this very unique initiative that brings together the three universities, the University of Maryland College Park, the University of Maryland Baltimore Curry King School of Law, and University of Maryland Eastern Shore, all of which invest people and resources to really ensure that this initiative continues moving forward in a positive way and providing research and knowledge that hopefully makes a difference to the agricultural enterprises in the state. This team remains strongly committed on this mission of supporting agriculture. And we truly hope that you'll find this conference another opportunity to benefit and increase your understanding of some of the issues that are facing the agricultural community from a context of agricultural law and environmental law. So with that, I do hope that you enjoy the conference today. And with that said, I will call on the next panelist. You know, it's interesting. I was looking at a picture up there, my picture, and that picture was nearly 12 years old. It's sort of anyway, thank you very much.
Good morning, everybody. And I'm going to call up our first set of panelists, and I'll read a little bit of their bios as they come up to the stage. We're going to have a discussion on the right to farm statute in Maryland and across the U.S. We have Professor Jesse Richardson, Jr. He is the Hal J. and Roscoe P. Poston Professor of Law and the lead land use attorney at the Land Use and Sustainable Development Law Clinic at West Virginia University College of Law. I should not try to read fast early this morning. And then our final panelist, which I will bring up real quick, is Tony Gorski. Tony specializes in environmental, natural resources, and agricultural law. In addition to providing advice on permitting and compliance, he represents clients in trial and appellate litigation in the state and federal courts and administrative forms. So I will turn it over to these two gentlemen to get started. I forgot the order we picked, but I believe it was Jesse first. And then I will walk down to take help with questions later.
Good morning. Thanks for inviting me here today. I'm going to kind of give an overview of Right to Farm and a little history about Right to Farm. I get to teach Right to Farm a lot in my land use law class, and I don't know how many people know this, but Right to Farm started with a 1972 Arizona Supreme Court case in Spur versus Del Webb. Del Webb was a developer that still exists, actually. And instead of building right outside of Phoenix, he leapfrogged out into Sun City, Arizona, out in the country. And my guess is that there was one owner of a cattle feedlot that wouldn't sell to him, Spur. But Del Webb went ahead and built his housing development anyway. And then after people started to buy lots and build their houses, all of a sudden they discovered that feedlots stink. I guess the wind was blowing a different way when they came to look at the lot, I don't know. And so Del Webb and some of the purchasers of the lots filed a nuisance lawsuit against Spur, the owner of the cattle feedlot. And the judge came up with a very interesting solution. So first, the judge found that the feedlot was a nuisance. And part of that was the odors, there was manure, the manure attracted flies, so it was a nuisance. But then when the court fashioned a remedy, the court said that Del Webb was partially at fault for coming to the nuisance. So the court said, Spur has to move, but Del Webb, you have to pay for Spur to move. Think about that for a minute. Who won that lawsuit? Del Webb, because he was trying to buy Spur out anyway. So the court kind of forced Spur out. Well, all 50 states, the legislature said that's not fair. if the farmer is there first, somebody that comes to the nuisance, and from the lawyers in the room, you've heard of coming to the nuisance, but it's really not a defense, it's just a factor. Well, all 50 states passed right to farm laws that made it a defense and said if the farmer is there first and the farmer complies with generally accepted agricultural practices, then it's an absolute defense to a nuisance suit by somebody who comes in later that the farmer was there first. And most of the states passed those laws between 1978 and 1983. In the intervening decades, some states, like Iowa, and I believe Ohio, Peggy, also exempted agriculture from zoning. Does Ohio do that? Yeah. So some states said, we're going to protect agriculture from the evils of zoning and the local government. And some states said, we're going to exempt agriculture from the building code. The next really significant developments in right to farm, though, didn't come till 1998, when Iowa and Washington State, the Supreme Courts of both states, found that the right to farm statute was a regulatory taking. And the theory of that was that basically the state, by passing that law, was forcing the neighbors to have an easement across their property for odors and noise and dust and that type of thing. So in the parlance of regulatory takings, that is a physical invasion and a categorical taking. So, you know, in the late 1990s, early 2000s, it's like, whoa, right to farm might go away. And there were some brilliant law review articles written during that time. I recommend one by this guy from WVU. And we all predicted that, wow, you know, right to farm's going to have to change. But it didn't. The Iowa Supreme Court started backing off. But before they backed off, they said, in 2004, they said not only does it violate takings, but it violates the inalienable rights clause of the Iowa Constitution. That means that people can not only get the value of the reduction in their land, but they could get damages for personal injury and that type of thing. But in 2022, the Iowa Supreme Court totally backed off on that. They overruled the inalienable rights clause case, which means that now in Iowa you can just get the reduction in the value of your land. And they also really kind of backed off from the Borman case that said it was a regulatory taking. I found this to be really, really strange, because also in 2022, the United States Supreme Court ruled on a case, Cedar Point, and said that when California passed a law that said that farmers have to allow labor union representatives on their property to talk to migrant farm workers, that is a physical invasion and a regulatory taking. So the United States Supreme Court adopted Iowa's reasoning, and Iowa said, no thanks, we're backing off. Now before, and I'm not going exactly in order here, but The most recent really huge change in right to farm came from a 2020 North Carolina case that was in the Fourth Circuit Court of Appeals, Murphy Brown. In that case, we had some intensive hog operations, CAFOs, concentrated animal feeding operations. And CAFOs have been a really big point of contention with right to farm too. Over the decades, courts have kind of struggled with, is a CAFO a farm? Should it get protections of right to farm? Some courts kind of lean toward no. So the state legislature stepped in and said, oh yeah, CAFOs are farms and they get protected too. But in 2020, the federal court found that landowners in North Carolina were entitled to $75,000 in compensatory damages and $5 million in punitive damages because of hog CAFOs. Well, that spurred this new generation of right to farm acts. And the changes to the Right to Farm Act came in several different ways. Number one, a lot of states changed their right to farm to say you don't have standing to sue unless you live within a half a mile of the farm. So if you're further than a half a mile, you can't even file a lawsuit. Number two, to have standing, you have to own the land or be a majority owner. Next, that immunity from local regulation got expanded. Not only is zoning bad, not only are building codes bad, but anything that the local government does is bad. And farmers shouldn't have to listen to that. And in response to Murphy Brown, the state legislature started placing limits on the damages that plaintiffs could get against farmers in a nuisance suit. No punitive damages. And some states said your damages are limited to the reduction in value of your land. Other states also started to broaden the definition of agriculture. We're going to talk about agritourism next. In a lot of states, agritourism is now agriculture protected by right to farm. And agritourism is defined very broadly. Agriculture defined very broadly. And probably one of the biggest things that states expanded on was attorney's fees. If you sue a farmer for nuisance and you lose, you have to pay the farmer's attorney's fees. That's a little bit of a deterrent because it could cost you tens of thousands or hundreds of thousands of dollars. Now, West Virginia, and don't ask me why, because we've never had any right to farm problems in the state. But they heard about Murphy Brown. And so West Virginia has the most stringent right to farm act in the United States. I call it right to farm on steroids. They have everything. Everything that I talked about, they have. The most troubling thing was passed in the last legislative session that said that agriculture is exempt from all local regulation. We are concerned, among other things, that means that local governments cannot enforce their floodplain regulation. That means local governments cannot participate in the National Flood Insurance Program. That means that the flood insurance of everybody in West Virginia will skyrocket in price. No more federal subsidies. All 55 counties in West Virginia are in the floodplain. So lots of uncertainty. And I'll mention one other thing before I turn it over. Like I said, West Virginia, for whatever reason, seems to be in the bullseye of this. And the West Virginia Farm Bureau and the West Virginia Department of Agriculture are defining agriculture very broadly. Basically, their position is USDA defines a farm as a parcel of land that produces at least $1,000 in agricultural products. You don't have to sell it, you just have to produce it. The West Virginia statute goes a step further and says any parcel of land capable of producing $1,000 in farm products. That's about every parcel of land in the unincorporated portions of West Virginia. No local regulation. There was a proposed plant in Hardy County, West Virginia. They have zoning. It was a fumigation facility to treat logs with methyl bromide so that we can ship them to China. Hardy County said prohibit it by zoning. The battle was set up. They said methyl bromide is a pesticide. Lumber comes from trees. That's agriculture. We're protected by right to farm. Luckily, I shouldn't say this, I don't want to be biased. We avoided that battle because that business decided not to locate in Hardy County. But we are set up for a battle in West Virginia. Like I said, if you produce $1,000 worth of ag products, the position of the state is I can have agritourism that produces $500,000. I can do whatever I want because I'm a farm. And I know there's been some recent developments in Maryland, so I'll turn it over to Tony to talk about that.
Thank you, sir. Is this working? Yes, okay. Maryland hasn't gone as far, obviously, as West Virginia has. And Maryland, however, started doing right to farm legislation back in 1981. The most recent change, I think, was not 1998. And that's interesting for us now because, as many of you know, we have a lawsuit that came out of Talbot County, neighbors suing a farmer over the use of DAF as a biological additive for their fields and the alleged nuisance that came from that. The way Maryland is structured is that there is a state law on right to farm, and what it requires is that if the agricultural operation has been in business for more than a year, then it is immune to tort lawsuits, nuisance lawsuits from neighbors for odors, noises, smells, dust, that kind of thing. And so in Maryland, that's what the state law says, and the state law encourages every county to adopt its own version of the same thing. And it allows some flexibility, and it asks or encourages those counties to set up their own, what we refer to as like an agricultural review board. And so in Talbot County, the neighbors had filed a complaint with the Agricultural Review Board. That's how the The lawsuit that's currently on appeal is started pending, or began. So what happens in Maryland is if you have a complaint, if your county has a review board, then you're required to file, and you have a complaint about a farm for odors of some kind of nuisance, you have to file with your local review board under the county code. And that review board will then review the activity, and I'll talk about what they're looking at in just a second. But the key is in Maryland, the protection from liability for farmers is applied at that point. You're not allowed to go to court unless you've gone through either the local board, and if your county doesn't have a complaint or a local review board, I'm sorry, then you have to go through the Maryland Department of Agriculture's mediation process. So there's a default. If the county doesn't pick up and do something and have a board, then the complaints are supposed to go to the Maryland Department of Agriculture and put through their mediation process. Some of you may be familiar with that. I don't know, they've had that mediation process for quite a few years now. I've had a couple clients go through it. It's a pretty good process. You get a mediator who's usually in your community, and they sit down with the farmer and the neighbor and figure out how to address their issues. It usually works pretty well. But anyway, so those are the two options. Now, if your county has a board, then the complaint of the neighbor goes to the review board. And the review board's job is to decide whether or not to decide whether or not there's a nuisance. That's a court issue. The review board's job is to decide whether or not what the farmer, A, is it a farm operation or an agricultural operation under the code? And B, if it is an agricultural operation, has it been in use for more than a year? And then whether or not its activities are what you refer to as generally accepted agricultural practices. And so the question that came up in Talbot County was whether or not the change from the use of commercial fertilizers to using DAF was a generally accepted agricultural practice. And what the local court decided was that it decided that the change was an operation in and of itself. So switching from commercial fertilizer to DAF was a new operation, was how the circuit court looked at it in Talbot County, and said that it was a new operation. The complaints were filed less than a year after it began operating, and so the farmer had no protection. All right, so that was appealed, and that went up to the Appellate Court of Maryland, which is the middle level. It's in the Maryland trial system. You have, if you go through a trial, you have one appeal, what we call appeal of right. You have a right to appeal, and it goes to that medium court. You don't have a right to take it up higher. You have to ask permission to take it up higher. So what happened in this case, they filed with the appellate court. The appellate court looked at it and looked at the code, the state's code, as well as the county code, and viewed them as pretty much, the county pretty much adopts and follows what the state has in its law. And again, agriculture is defined pretty broadly. Maryland defines agritourism very broadly as well. So when you look at what the circuit court did, the circuit court's decision, remember, was that the change from commercial fertilizer to use of DAF to apply on the fields was, they were storing DAF as well. They had a storage facility constructed, bunkers, I think, and so they had DAF storage there too. And so the neighbor's complaint was not only the use of it was causing odors and flies, but that the change was also this now storage. Now the farmer was using, based on the record, the farmer was using the DAF that he stored on his own farms, just other locations, as well as the location at that one point. And so what the local court decided was that that whole change to DAF and to storage was an operation, an agricultural operation, and that was new. So get to the appellate court, and the appellate court looked at it and went back through what Maryland had done beginning in 1981 all the way up to today. And what the legislature adopted in 1981 said that an agricultural operation and any changes to it had to be ongoing for a year. Well, in 1998, the Maryland General Assembly, there was a proposal to remove the 1-year requirement from the statute altogether, so that once you establish your ag practice or your agriculture operation, you were good to go. You were protected from tort liability. And that didn't pass, but what did pass was to get rid of the 1 year, get rid of the language discussing changes. So the statute from in 1998 forward became one where if an agricultural operation was in place for more than a year, it was protected from lawsuit, protected from tort immunity from neighbors or tort lawsuits from neighbors. And so the difference being that if you have a farm, in the old statute, if you had a farm and you made some change, whatever that might mean, then that change was subject to a 1-year limitation period before, once it was in effect for a year, then you gained the immunity as the farmer. So by taking out the change part, Maryland's law now says, as of 1998 forward, so it's been that way for a while, Maryland's law says that if the agricultural operation is there more than a year, and as long as they're operating in compliance with the law and using generally accepted agricultural practices, then they're not going to be, no one's going to be able to, the neighbor's not going to be able to sue them in the courts for a nuisance. So then what happened in Talbot County was the argument about the change, and what the appellate court said was, no, Maryland used to say that the change had to be in place for a year before you had protection as a farmer, but it was changed in 1998, so it doesn't say that anymore. It now says just the agricultural operation has to be in place for a year. So you're looking at this definition, what is an agricultural operation, and is there something about this particular operation in Talbot County at the farm that made it so that the agricultural operation itself was something that was different or was new, and the appellate court said no, that was an incorrect interpretation of the code, that based on the record, this change in practice from commercial fertilizer to application of DAF or biosolids was not an agricultural operation, it was a practice within the agricultural operation. And so what the court talks about is the idea that if someone has cows and they want to switch to poultry, or if someone is growing grains and they want to raise poultry, that those are the kinds of things that a farmer should be allowed to do to make their farm sustainable. And so changes in how the farmer goes about conducting its agricultural operation are just practices within the operation. And if you think of it in that sense, it's, in some ways you can think of, obviously anyone can think of pretty extreme situations where there are changes that are made, but one of the examples is if you use commercial fertilizer on your farm and then you want to build a tank for a large supply of commercial fertilizer for your farm and your family to utilize, that would not be something that is a new operation. And so, because that's a practice within the farm operation or the agriculture operation, and so the question then becomes, is it a generally accepted practice? And I imagine there's a point in time where one of the things that the neighbors were arguing in the Talbot County case was that there was the operation was the storage and distribution of DAF, not the application of the fertilizer or the DAF instead of the fertilizer. And the court looked at that basically as, the Agricultural Review Board determined that that was a generally accepted practice, that if you utilize DAF, you may have a storage facility at your location. And just because it's not all being used on that one property doesn't mean it's not part of your agricultural operation. And so you're allowed to do that. So, and in Maryland, what happens is when the local review board takes a look at a complaint, and they go through and they hold a hearing and they listen to all the witnesses and they make decisions, they make factual findings and say, here's what we believe, and this is or is not a generally accepted agricultural practice. The appeal route from that is to ask a local court to review their decision. It's called a petition for judicial review. And that review is not a new trial, and it's really not supposed to at all look at the evidence and the facts. It's supposed to look at what the board decided and then look at what the board's record. So the test when you go up on appeal, the test is, was there enough evidence in front of the board to support their decision? And we call it the substantial evidence test. And the substantial evidence test is, the court, and this is the idea is that the people who hear the witnesses, which is the board, the local board, as they sit and hear the witnesses and look at pictures and go through the testimony and all that, they're arbiters of the facts. They are the ones seeing, who's credible, who's not a credible witness. And this is a typical appellate review process for factual decisions. Most appellate courts don't look at the facts that a judge decided. They only look at the facts a judge decided to see if there's enough evidence to support those facts, not whether or not they think the judge is right. And that's how the appellate courts look at these commissions, the local board decisions. Is there enough evidence, whether it's photographs, whether it's testimony, whatever it is there enough evidence in front of the board to support their decision that it is a generally accepted agricultural practice? And so an appellate court and the circuit court should have looked at the board's record to say, all right, here's what the board said, it is generally accepted, and they wrote reasons as to why they thought it was. And so are those reasons in evidence? Is there a document, is there a witness testimony, are there photographs that support what the board found? Okay, so the circuit court is not supposed to look at let's say there's three or four people testifying for the farmer, 3 or 4 people testifying for the neighbors. The circuit court, when it reviews that decision, isn't supposed to look at what each of them said and decide what evidence they think should control. In other words, I believe the neighbors or I believe the farmer. The circuit court is supposed to look and say, is there enough evidence that supports what the board decided? And in this case, that it was a generally accepted agricultural practice to have DAF stored on the farm. And so, and the other aspect of what the court disagreed with, or what the appellate court, I'm sorry, I keep saying court, what the appellate court decided in overturning the circuit court's view of that case in Talbot County, the appellate court said, number one, the statute doesn't say that the change has to be in place for a year, only the operation. And number two, the court looked at it and said, what you're supposed to look at is whether or not there's substantial evidence, not whether or not the judge or the appellate court would agree with the decision. It's not about whether the local board, and this is an odd phrase, but it's not about whether the local board is correct. It's about whether or not there's enough evidence to support the local board. And that's a weird phrase for most people, but not for lawyers. And so the real issue is, think of it this way. You may, if you were to consider investing for your future and you had 4 different proposals in front of you, one of which was snake oil, and you knew you weren't going to do that. The other 3 were reasonable, but there was something about one of them that made you think, I like that one better, I'm going to go with that one. Well, that's what a reasonable mind would do. A reasonable mind would look at all the things in front of it, ignore the ones that are crazy, wrong way to say it, but ignore the ones that aren't well supported and go with the ones that are supported. That's what the court is doing when it's reviewing these board decisions or when it's looking down at what a circuit court does. It's looking at the 4 options I spelled out for your future investment are the record for the agency decision. It looks at all the evidence, all the testimony, and are there things in the evidence and the testimony, whether it's a transcript or documents, is there something there that says that the board relied on and that is factual and is correct? And as long as it's in the record and the board has something that it's pointing to and saying, here's the part of the record that we believe shows that this is an accepted, generally accepted agricultural practice, the court's not supposed to consider what other people said about it. Because if you think about it, the judge in the circuit court case reviewing the board, they're not sitting in front of those witnesses and listening to what they say and hearing what they have to say. They're looking at a transcript. You're reading what someone said, just a written version of what was said, or you're looking at their documents, you're looking at their photographs. The courts in the United States have always said that the trier of fact has to see the witnesses, has to see the evidence, has to see the case presented. And so if you don't have that opportunity, you don't understand why the board thought this piece of evidence meant more than that piece of evidence. You have to be there. And if you think about it, it makes sense in everyday life. When you make decisions, you don't like to make decisions unless you get the information yourself, or you have some indication that this information is going to be accurate. You're not, and that's the other part of what the court had problems with. Now, the appellate court decision overturned what the circuit court said. It agreed with the local board and said this is an agricultural practice within an agricultural operation, and so they had protection. The operation had been in, the property had been a farm use for generations. And so that was the other thing, of course. The question, it became a bit of a discussion about if you sell your farm, does the buyer have to start over again? Does the 1 year have to start to run again? So whoever buys your farm operation is in jeopardy for tort lawsuits for a year until they've established their own agricultural operation. And that's not how it works. It runs with the use. So if you have an ongoing agricultural operation and you pass away and your children inherit it, they inherit that protection from tort liability as well. If you sell it to someone else, they do too, as long as they don't stop operating. If they stop operating and then 3 years later come back and want to set up a hog farm, it's not going to work the same way. So if there's a pause, and this is similar to a lot of zoning situations, if there's a pause in your business that stops it, when you restart, you don't necessarily have those same protections anymore. But it's not based on the sale of the farm or inheritance of the farm or change in ownership of the farm. It's just about the continuation of the operation. It's not the think of it this way, it's not the operator, it's the operation. So things can move forward and go. How are we on time, Paul? I know we were going to do some Q&A, and I'm
8 minutes left for Q&A.
okay. If anybody has any questions, I'd be happy to address them. Someone in the back?
There's a microphone coming, but I'll just project if that's okay.
I can hear you.
I appreciate all that information and background. Martin Crew, Maryland Department of Agriculture. Questions directed to Tony. Definitely welcome Justice's perspective on this. And it's about thresholds as it relates to right to farm and what's protected. Obviously, the assumption would be that an agricultural operation is compliant with all Maryland state laws. One of those state laws is a nutrient management plan after a pretty low threshold, $2,500 in revenue or $8,000 or 8,000 pounds in livestock weight. I guess my question is, especially when you're talking about these local ag reconciliation boards that may or may not exist, is there any mechanism to clarify that? And I guess the underlying question is, do you need a nutrient management plan to be protected under the right to farm, or the backyard flocks and a few horses in the backyard also falling under this?
The best way to think about it is if there's an obligation, if there's a legal obligation to have a plan or to have a stapler at your desk, whatever it is, if there's a legal obligation to have something as part of that you're required to have in order to have a legal operation, then that's a requirement. You have to be operating in accordance with the law. Generally, that's thought of as the big picture kind of things. So, for example, if someone filed their renewal of their CNMP or their NMP, their annual renewal for whatever general permit they might be covered under, if they filed their renewal late, I don't think that the court would say that that's a lapse that resets the 1 year. And if you think about it, you could have these permits only run for a certain, some of them are annually renewable, some of them are 5-year permits. It all depends on what you're looking at. But the last thing that the state wants to do, I think anyway, is to have someone build their, let's say, a dairy operation. You get everything in place, you get your CNMP, you have all your permits, and you go, and you spend $1.5 million setting up a milking parlor, and you do everything else that you need to have for a dairy operation, and then you file an application, a renewal late next year, and your $1.5 million investment is lost, because now you are subject to tort liability, and I'm pretty sure it's not going to work that way. There's not been any case like that, but I would expect that for minor violations, like if you had a violation of your NMP, I don't believe that would reset the 1 year, or that someone would be able to say, you had an NMP, but you renewed it too late, or you had a violation that the state has come in now and cited you for, and so when you got cited for that violation, your liability protection was gone. I don't think that would be the case. Other questions?
Where do I need to run to next?
No, nobody.
I believe you addressed this, but just to clarify, so agritourism is included in the right to farm for Maryland. Is that correct?
Yeah, agriculture operation, agriculture is defined to be this wide set of things, and one of them is agritourism.
What about animal-assisted therapy?
To the extent that having the animals on your property constitutes an agricultural operation, and I think it does, then you would be covered.
Morning. I sit on a board in Harford County where we are struggling with ag accessory uses. And what is the definition of agriculture, and what is its definition of an actual permitted accessory use under ag zoning? And so this is very interesting in the context of right to farm. But it is a question, agritourism, is that a permitted ag use? Is it an agricultural use?
Unfortunately, in Maryland, the state law is very broad as for its definition of agritourism. It covers anything you can practically think of. Camping, for example, is in the state's definition of agritourism. But it's not a preemptive definition. In other words, that definition is the state's definition. It doesn't mean that every county has to follow that definition. The counties are allowed to adopt their own definitions in their zoning codes for agritourism. And many of them, some have followed the state's definition. Many of them have just picked things and put some things in, but not other things. And sometimes they say, et cetera, or as, the ending of the code will say similar activities, that kind of thing. And so it's a question as to what is. But each county is going to have a definition that it uses for agritourism. And that's, for your purposes on that board, you would be looking at just the county's definition.
And a follow-up, another question on a different concept. When one has a niche, a small agricultural production on small parcels of land, and that parcel of land is in a community that has development regulations, this has come up in my area. Is there any right to farm protection if there is a recorded set of development regulations that restrict the numbers of animals or the types of animals on a piece of property?
You're looking at two things. You're looking at the idea of an agricultural operation and where it can be. And I think that an agricultural operation, I know some locations on the Eastern Shore that grow specialty peppers for Asian food markets in DC, and they don't need much space. And so, excuse me. So I think that can happen anywhere, but if you buy a piece of property, and the flip side of your question is contract law. So forget about ag. and look at the contract. When you buy a piece of property that has deed restrictions on it, you're signing a contract that says you're going to stick to and abide by those deed restrictions. And it doesn't really matter whether you have a right to farm or not. You have contracted with all of your neighbors to comply with these restrictions, and those are the restrictions that will apply.
Thank you.
Okay. And I want to thank our panelists for coming today. And I guess Jesse gets to stay up for the next panel, but Tony's free to come downstairs.
And I empathize with you, because those boards are not easy to sit on and have those things, because a lot of that, for example, your question, I don't know that it's right for your board to make that decision, because it's a contract decision.